This is Alex Carlin. The Atomic Safety and Licensing Board proceeding is now reconvening. Mr. Lutz, are you with us out there?
Judge Carlin, this is Joe Duiker. They have not yet returned.
Where are they?
They are in the building at the moment. I don't know their exact whereabouts.
Okay, well, I didn't think we worried them that much by our questioning. We were just getting started. I think we are going to proceed, and if they want to show up, they can show up. Mr. France, could you please come to the podium for our question?
If it may please the board, I'd prefer, if I could, to speak from the desk here, because I have a combination of information both in hard copy and a laptop. I'm not sure I can bring all that conveniently up to the podium. And I'll be needing to refer to some of the information.
I think that's all right. I think that'll be all right.
Thank you for your indulgence.
I want to ask one question about timeliness. Now, this petition was filed on October 17th, 2012. The deadline set forth in the Federal Register was October 15th, 2012, 2 days late. Are there any, I was looking for the case law. Are there any cases which held that a request for a hearing where the party had standing and where the party had an admissible contention got thrown out because it was 2 days late?
I don't know about 2 days late, but we do have a case involving Seabrook at COI 99-6, where the petition was 7 days late. And in that case, the board found that the commission found that the petitioner was untimely.
Did it meet the other criteria I referred to?
I don't recall.
No.
I believe it was.
I mean, I don't think there's any case out there that holds, look, you got an admissible contention, you got standing, you're 2 days late, you're out of here. I mean, do you have a cite for that?
Yeah. In the Seabrook case, I think it was rejected solely on timeliness. They didn't even look at the other attributes of standing.
Was this the initial petition for hearing, or a new contention?
This was the initial petition to intervene.
Okay. Well, then the CLI on that is?
It's CLI 99-6 at 44 NRC 201, pages 222 and 223.
Okay.
I'm sorry, it's 49 NRC.
49 NRC, okay. All right. Mr. Welke, could you bring up the August 16th, 2012 Federal Register notice of this proceeding?
Oh, you all right?
Welcome, Mr. Lutz. We're proceeding with the questioning of Mr. France.
Okay, thank you very much. Sorry about the delay.
Can you get the new show?
So Mr. Welke was going to bring up the August 16th, 2012 notice. I would you move to page 49465, please, Mr. Welke. And at the bottom left of that page, if you page down, there is a discussion, and I will quote it. And I'd like you to answer some questions about these relocated specifications, Mr. France. The quote is, quote, relocated specifications. Some of the proposed changes involve relocating CSTs, and that's current technical specifications, LCOs, that's limiting conditions of operation, to licensee controlled documents. SCE has evaluated the CST using the criteria set forth in 10 CFR 50.36. Specifications identified by this evaluation that did not meet the retention requirements specified in the regulation are not included in the ITS. These specifications have either been relocated from the CTS to either the licensee controlled specification or the UFSAR. So my questions sort of focus on this, and let's kind of eliminate all these acronyms. Chairman McFarlane has adjured us to try to reduce acronyms if we can. And all I want to really talk about is what's a current specification, and if you're changing a current specification, a technical specification. So, as I understand it, currently the tech specs, the surveillance frequencies are tech specs that are in the Edison's license. Is that right, Ms. France?
That's correct.
And as I understand it, the licensee can change those tech specs under 5059.
That's correct.
Okay. Now, if you take a tech spec that's currently in the license and you relocate it to a licensee controlled document, is it still, quote, incorporated in the license, close quote?
No, it's not.
Is it still a tech spec?
No, it's not.
So when you talk about relocating a tech spec, that's kind of confuses me. You're not relocating a tech spec, you're eliminating a tech spec. It's no longer a tech spec.
Yeah, I think what the intent here is, and this is a staff document, not ours, the intent is that it's a relocation of a provision from the tech spec.
For Mr. Welke, reconnect here. Mr. Lutz, did we lose you there for a little bit?
Yeah, can you back up to the start of his testimony, please?
Well, could you hear what we were talking about?
No, it went.
Or they had no reception at all?
After the part when he said it's.
I think what.
Go ahead.
I think what's happening is when I pull up a document to discuss, it may overload the system and drop the video link and cause things to be a problem. So maybe I can restrict that. But we were focusing on the announcement in the Federal Register on August 16, 2012, that announced the proposed changes that are being requested by Southern California Edison. And one of those requested changes, the one that's being contested in contention 1, is the relocation of specifications on page 49465. And what Mr. France, I believe, said was that if you take a tech spec and relocate it out of the license and put it into a licensee-controlled document, it is no longer a tech spec. Is that correct, Mr. France?
That's correct.
Okay. What is it?
It's a licensee commitment, and it can only be changed in accordance with the provisions that govern that particular document. In the case of the surveillance frequencies, which are being relocated to the Surveillance Frequency Control Program, we can only make changes to that.
Right, well, I'm going to get to that later, but it's not a tech spec anymore. It's a written commitment, a licensee commitment.
That's correct, and it's controlled
Okay.
by a program that's in the tech specs.
Okay.
And so there are still some provisions in the tech specs dealing with surveillance frequencies, just not the numerical values of those frequencies.
Okay, now you've taken this, let's say you get your wish, your client gets its wish, these tech specs are deleted and these provisions are put into licensee controlled documents. Does the public have access to those licensee controlled documents?
No, it does not.
So there's no public access to see this?
The public obviously can see the changes we're making
Today?
today.
But after you make the changes, it goes offline, public can't see it?
That's correct. The staff, of course, we have to document those changes internally, and those have to be available for NRC audit.
Right. Okay. Consequences. Let me ask this question. Let's assume that there's a surveillance frequency provision, and it's in the license. It's called a tech spec. You take it out of the license and put it in a licensee-controlled document. It's a written commitment by the licensee, but it's the same tech spec, exactly the same frequency requirement, whatever it is, once an hour, once a month, it's the same, but it's been moved. Let's assume for a moment that the licensee exceeds that tech spec, or that surveillance frequency. I won't call it tech spec anymore. They don't meet it, they miss it, they do something inviolable, but they don't make it. I presume that the licensee has to take certain actions in reaction to missing a surveillance frequency. Would that be right?
That's correct.
Okay, now let me then ask this. Are the licensee's duties different if it's in a tech spec versus when it's in a written commitment?
I don't believe so, no.
Okay.
Let me clarify that.
They have to do certain things.
If there's a missed or inappropriately performed surveillance, we still have to do exactly the same thing as we would do previously.
How about notice to the NRC?
I don't know that we have to give notice to the NRC.
You need a text, miss a tech spec.
I'm sorry.
Do you have to notify the
I'm
NRC?
sorry, no, because the surveillance requirement is still in the tech specs. We still have to perform those surveillance requirements. And so if we miss it, we'd still have the same reporting obligation.
If it's in a tech spec, do you have to, and it's missed, you have to report it to the NRC?
I believe that's correct under 58.7.
If it's not in a tech spec, it's in a written commitment, do you have to report it to the NRC?
I'd have to go back and actually look at the language of 50.73. I believe that if it's a missed surveillance requirement, we do have to report that.
Suppose it's not missed in the sense that it was not performed, but it's performed, say, a month late.
I think the requirements would still be the same.
All right.
Check.
We'll ask the staff that question too. Maybe you can start looking at the regs and help us on that one. Next, I'm trying to figure out what are the consequences of taking this surveillance frequency provision and moving it from a tech spec to a written commitment. Unilateral change is the next question. Assume it is relocated, the surveillance frequency is relocated to a licensee-controlled document, a written commitment. As I understand it, Edison can unilaterally change that provision whenever it wants to, so long as it meets 50-59 criteria.
No, I don't believe that's accurate.
Okay.
The changes are governed by a license provision in the tech specs. The tech specs refer to an industry guidance document, NEI 04-10. And to change the frequency, we have to comply with the provisions in NEI 04-10.
Well, NEI 04-10, okay, that's an industry, Nuclear Energy Institute's an industry document, right?
And that's correct, and it's also now referenced in our proposed tech specs.
Okay, so it's incorporated into the tech specs, and that's how it becomes mandatory or operative, you're saying?
That's correct.
Okay. Do you have a question on that?
Yeah, I do. Dealing with 5059, is it your position that 5059 still applies to this surveillance frequency control program?
No, we don't believe it does. Again, we believe it's our commitment and license requirement to comply with NEI 04-10. The 10 CFR 5059 applies to changes relative to the final safety analysis report. We are not locating the surveillance frequencies in the FSAR, at least nothing. We're not changing anything in the FSAR in that regard. And so, in general, 5059 would not be applicable to these changes.
Let me interrupt and ask you a question. Okay, so are there any surveillance frequencies specified in the FSAR?
There may be some, but I don't think it's a comprehensive set, such as you'll find in the surveillance frequency control program.
So, and you would not be changing those by this?
If there were, for example, a surveillance frequency that was both in the FSAR and in the surveillance frequency control program, we would have to comply with 5059 for that change to the FSAR and NEI 04-10 for the change to the surveillance frequency control program.
Would the process, the NEI process, I think it's 410, would that process be considered a parallel to 5059?
Personally, I think it's much more stringent than 5059. There are a very complex set of steps and evaluations that have to be undertaken to make a change to the surveillance frequency under NEI 0410. That document itself, by the way, is around 40 or 50 pages long. In contrast, 5059 takes up about 1 page. So it's much more detailed. We have to go through both a qualitative evaluation of the impact of the change and including consideration of past surveillances, including whether we missed any surveillances. But we'd also have to consider surveillances that had not been successfully completed. We'd also have to consider other reliability issues with the component in question. All that's undertaken as part of the qualitative evaluation process. There's also a quantitative process which is more risk-informed, that looks at the impact on the PRA and the change in core damage frequency. We have to do both of those.
And one of the outcomes of that process might be that a license amendment is required?
No. The only outcome of that would be either we can't change the surveillance frequency, or we have to change it in accordance with those provisions.
So let's assume that going through that process for a surveillance frequency, you conclude you can't change it. The option to submit that to the commission or to the staff for their evaluation of changing that would not be considered.
Judge, you're correct. We could do that. That's an option if we did not meet NEI 0410.
Can you help me? NEI 0410, an industry document, where is it made mandatory that I can cite and say, here's the requirement?
Let me pull up.
Is it it's not in the current license, is it? It's in what you're proposing to change if you get the proposal accepted.
That's correct.
Okay.
And I'll refer the board here to our license amendment request, attachment 1, volume 14, page 83, and this will be text spec 55218B, and that says changes to the frequencies listed in the surveillance frequency control program shall be made in accordance with NEI 0410, risk-informed method for control of surveillance frequencies, Rev 1.
Okay.
But I'm a little confused here because I see in the staff's reply brief to our answer, I should say, to the petitioner, they say that, and I'll quote from, let's see what page it is. They have a quote, find the page number here. Page 20, about towards the bottom of the page there, it's the last full paragraph. It says, moreover, COPS claim that SCE will have free rein to reduce surveillance frequency requirements, ignores the requirements of 10 CFR 5059, which is it was not applicable. They go on to say, the staff goes on to say, that section requires all licensees to evaluate changes to plant procedures and licensee control documents and to seek a license amendment under 10 CFR 5059 for any changes that result in a substantial change from the previous analysis or result in a more than minimal increase in risk. And that's the wording, a paraphrase of the wording that's in 5059, if I recall. So how was your statement that you made a moment ago relative to 5059 consistent with the staff's position as espoused in their answer?
It is not. We don't agree with the staff on this point. We believe that changes to the surveillance frequencies are controlled by, or will be controlled by NEI 0410 and not 5059.
Doesn't that imply that there's a material dispute here that we should be looking at under a hearing?
This is certainly nothing that the petitioner has raised. This is.
It seems as though they did.
The petitioner has not referenced 5059 at all.
Oh, but they've made the statement that you're able to change it at will, and the staff says, no, you're not.
And we don't say we're able to change it at will either. We believe we have more restrictive requirements under NEI 0410 than we do under 5059.
Well, let me say that the staff says that it has to be under 5059.
Which page is that on the staff?
I'm referring to
Well,
page 20.
Let me point out that the board, in looking at this, has concluded that 5059 probably does not apply in the sense that there is no requirement to do a 5059 evaluation. I don't know how you apply 5059 without doing a 5059 evaluation. Yet we do have the statement that Judge Broad had just mentioned.
Judge, of course, I agree with you entirely, and we just disagree with the staff on this.
Well, can we ask the staff to address that here? I will jump in. Does it, I mean, I'm somewhat surprised by Mr. Francis' position. I thought I heard repeatedly that, you know, well, it's going to be moved into this licensee controlled document, but no worries because there is this thing 5059 and they can only change it if they meet those criteria. Now he's saying, oh no, that doesn't apply to us.
Certainly, Your Honor. First, the Surveillance Frequency Control Program, and David Roth for the staff. The Surveillance Frequency Control Program, as described in their application, would put into their Tech Spec 5 section the requirement to use the NEI document. That becomes then their controlling license for changing the surveillance frequencies.
Is that in lieu of 5059 or in addition to?
No, it's in parallel. 5059 is still going to be controlling them if they attempt to change a document that requires them to seek an amendment, such as use something other than the NEI document to control the surveillance frequency changes. They're going to have to come to us.
All right, well, let me ask, is the NEI in addition to or in lieu of 5059? I mean, does 5059 just go poof because somebody cites NEI 0410 or whatever it is?
No, certainly the regulation continues to exist, and to the extent that any particular change that they're doing in accordance with NEI 0410, which shouldn't cause them to violate 5059 if they're following it correctly, would continue to apply.
So do you still stick by your statement that this section requires all licensees to evaluate changes to plant procedures and licensee control documents and to seek a license amendment under 5059?
Well, actually, I want to refer to the actual LAR, because we look at the source of the confusion here. If we pull up attachment 1, volume 15 of the LAR.
LAR attachment 1, volume 15, yes.
And
I don't have it in front of me, but we're going to go look at it afterwards.
certainly, within that, this is their proposed notice of hazards evaluation. Within that, I'll quote here in a second. Not including.
What page are you on? Volume 15 must be pretty long. You know, there is this rule, you can't just cite a big document, you have to give us the page now, you know.
Well, it has two numbers. The numbers, as in the PDF version of the LAR, is attachment 1, volume 15, revision 0, page 9 of 26. But it is also labeled above that as page 8 of 24.
That's very helpful, yeah. Page 8 of 24.
It's the original PDF version, and so it'd be the version.
All right, so what does it say?
Right. So this is answering the question of, does the proposed change involve a significant reduction in the margin of safety? And it's in discussion of reduction of details, and the removal of the surveillance frequency is not a removal of an item from the tech specs. It's a removal of the level of detail within the technical specifications. The surveillance requirements remain within the technical specifications. And I'll get back to that in a moment here. But not including, this is what the licensee has written, not including these details in the technical specifications is consistent with Rule 1332 issued by the NRC, which allows revising the technical specifications to relocate these requirements and surveillances to a licensee control document controlled by 10 CFR 5059, 10 CFR 5071E, or other technical specification controlled or regulation controlled documents.
So that provision says that it would be controlled by 5059?
This is in the generic, the consideration of no significant hazards the licensee has put.
Well,
This is,
that's a different thing, isn't it? No
It is.
significant hazard
Their
consideration
description.
determination.
Now, again, in terms of what's actually controlling the change in the surveillance frequency, if they wish to change the surveillance frequency for a surveillance where the details have been shifted into the licensee controlled document, it's going to tell them in accordance with the surveillance frequency control program. Then they have to look at a program described in Section 5 of the tech specs. It's going to tell them to go to the NEI documents. They then must follow.
No, I understand when you say Section 5 of the tech specs, we're talking about a real tech spec in the license?
Yeah, their
Okay.
proposal is to
Okay.
encompass the
Okay.
administrative controls of the actual license.
All right.
Then they must comply, because now it's within the license, within the requirements of the NEI document, as they make their evaluations over whether or not they can alter the surveillance frequency that they've chosen. Now, if I may get back
so
to,
that is not a 5059 process.
no, it's a very pinpoint process that they're going to be using this program. They can't deviate from that program, because if they say, I want to do something else, I don't want to use the NEI document, Rev 0 or Rev 1, I believe is the one they're using. If they want to use Rev 2, they can't just use Rev 2 when it comes out. They'd actually have to get an amendment if they wanted to shift from Rev 1 to Rev 2, because, and I'd have to verify it real fast, but the best of my memory is the revision is also specified within the tech specs. Thus, if they want to change revisions, if NEI comes out with a new guidance document, they need to use 5059.
So that's the answer. There is no 5059 evaluation done. That's the answer, right? It's done in accordance with this, with the surveillance frequency.
I want him to answer that. I want him to-
Well, it depends, I have to put in the thought as we, drafted our answer there, because clearly it's caused some confusion. There is no question that the surveillance frequencies are changed in accordance with the NEI document. They're properly reviewed in accordance, because it may come back, if somebody wants to reduce the frequency, they might run it through the process, and they might determine, we can't do this. So if the process they're going to use is the NEI process, it's not the 5059 process, the 5059 would come in if they want to use an alternate process, because then they're going to have to get a license amendment to use a different process other than the one specified by the proposed license, which is the NEI document.
I understand. So basically, if they wanted to use 5059, they would require a license amendment, which seems like a kind of a strange combination, since 5059 is meant to avoid a license amendment, but I understand what you're saying.
And if I can just add, if that's how the staff's interpreting this language, that is how they're interpreting their pleading, then we agree.
All right. Can we move on? We're still focusing on Mr. France on the consequences, I guess, of taking a surveillance frequency out of the tech specs and moving it to a licensee-controlled written commitment. Enforceability. Let's talk about, is it enforceable? Is it as enforceable? I will quote you from the 1993 final policy statement on tech spec improvement that Mr. Lutz has referred to, July 22, 1993, at 58 Fed Reg 39134. Quote, the Commission concludes that some requirements previously contained in the tech spec should be relocated to other documents that do not have the direct enforceability of tech specs. If you move it to this licensee-controlled document, is it enforceable?
Yes, it is, under Appendix B to Part 50.
Appendix B, or
B as in
B as in boy, Part 50,
Yeah,
all the assurance regs.
So under Criterion 5, that criterion requires that there be procedures to govern safety-related activities, and that the licensee implement those procedures. If we did not perform our surveillances in accordance with the surveillance frequency control program, we believe that would be a violation of Criterion 5.
So you're saying that's a QA, it's not directly enforceable, they say here, do not have the direct enforceability of tech specs. Tech specs are directly enforceable. And this thing, if you move it out of tech specs, it's only indirectly enforceable as a QA?
I'm sorry, Judge Carlin. Would you repeat that question?
The quote I gave was that if you relocate it to other documents, they do not have, quote, the direct enforceability of technical specifications.
If we were to change a frequency and did not use the NAI 0410 process, that would be
I'm not talking about a change, I'm just talking about moving it, the same document, same frequency that's in there today, you just take it out and you put it in your own little pocket somewhere, and that's your licensing controlled document.
Okay, that would be a violation of Criterion 5 of Appendix B.
So it's not directly enforceable, it's indirectly enforceable as a QA, it's your position?
Well, no other matters whether you call it direct or indirect, it's enforceable.
Okay, the compliance policy at page 39, 138 has an enforcement policy in it at the end, and it says, quote, compliance with technical specification is required by the commission, and adherence to commitments and licensing controlled documents is expected by the commission. Is the same answer? I mean, it seems like there's a difference between tech specs compliance is required, compliance with commitments is just expected.
In this particular case, the surveillance frequencies would be part of our set of procedures, and if we don't follow our procedures, that's a Criterion 5 violation.
Okay.
So we're in a situation where you do, assuming this LAR is approved, you will have a I don't know what you call it, a TRM or LCS, whatever you call it. You will have surveillance frequencies in that document that can be only changed by applying the surveillance frequency control program, which is in the technical specifications as a requirement.
That's correct.
Specifically, okay. There are other surveillance frequencies, other surveillances that are done that are many instruments that are not part of the technical specifications, many of which are very important to the safety of the plant, but are not in the technical specifications. Though the changes to those are done routinely on a 50-59 basis, is that correct?
That's correct.
Okay.
And I might say, in most cases, the surveillance provision probably is not discussed in the FSAR, and therefore changes can be made without violating any of the 8 criteria in 5059C.
Right. So the vast majority of surveillances, some very important, are totally done outside of any of this process.
That's correct.
I just wanted to make sure that people understood that. What about methods of performing surveillances? Is the surveillance performance method documented in any formal way, or is that just part of the surveillance procedures of the plant?
The surveillance method sometimes is actually discussed in the tech specs, and that will remain in the tech specs. The tech spec bases oftentimes provide a little bit more detail on the nature of those surveillance requirements. And of course, we do have procedures which go into a fair amount of detail on how surveillance requirements are performed.
All right, but not all surveillance methods are documented in the tech specs. Some are.
That's correct.
All right. Okay.
Yeah, just to make some sense out of these various acronyms, could you briefly relate the 1977 tech specs, okay, to the current tech specs, to the standard tech specs, to the improved standard tech specs?
Yes, and what's happened over time is the standard tech specs have been improved, and then they've been improved some more. And so even the improved standard tech specs go through an evolution. We were one of the first plants actually to have the improved standard tech specs for a combustion engineering plant.
I think you were the lead plant, if
Yes.
you recall it.
And that was back in the 1990s. Since then, there have been a number of changes to the improved standard tech specs. And what we're trying to do now is basically upgrade our current tech specs, which are the standard tech specs from the 1990s, to basically the 2011 standards.
And when we keep talking about I don't know the standard text, quote, standard tech specs from Adam, okay? There are some tech specs in the license. There is this other thing you talk about, which is the standard tech specs and the improved standard tech spec. Now, the standard tech specs, I guess those are the tech specs that come out of this new Reg 1432.
Yes.
And new Reg is a guidance document, right?
That's correct.
And it's guidance from the staff, right?
Correct.
It's not legally binding on us, is it?
That's correct.
So standard tech spec sounds like it's important, but as a legal matter, it's not legal. Those standard doesn't mean anything as far as I'm concerned, as far as legally binding on us.
You're correct. It's not legally binding on you, but we are adopting just the standard industry practices, which have been approved for other plants and are endorsed by the NRC standard.
Is that kind of everyone else on the block is doing it, Mom, so it's okay for us?
Well, I think it's fair to say, unless you have something from the petitioners that indicates that it's not safe or not legally adequate, I think you're...
Well, a contention to be admissible has to meet certain criteria, but okay, there are these things, standards tech specs that come out of new Reg 1432. Okay, that just helps me.
I just wanted to discuss the process a little bit more. Now you do a surveillance, in the future you will do a surveillance from the TRM, let's say. If that surveillance results in a finding that the tech spec value was missed, is anything different in this new process versus the older process?
I don't believe it is, no.
So you would have to file a tech spec violation.
I believe so. Again, I need to check that to verify that's the case by looking at the language of 50.73. I believe that's the case, yes.
All right, so there would be a licensee event report saying that you missed your tech spec, and whatever ramifications come from that, you would receive the same ramifications regardless of whether you did the surveillance the new way or the old way, or whatever the frequency is.
That's correct.
I have a question, Mr. France, based upon the August 16, 2012 notice. I'm not going to ask anybody to bring it up because it may break our video link with Mr. Lutz, but on page 49467, there is in the center column a discussion that's headed relocated specifications, and there's a question or a dialogue there about whether the proposed change, relocating the specifications, involves a significant increase in probability or consequences. And here it goes on to say, the response is no, it won't increase the probability or consequences of an accident. And the answer is no. Quote, the proposed change relocates requirements and surveillances for structures, systems, components, or variables that do not meet the criteria of 10 CFR 50.36 C2II for inclusion in the technical specifications. Okay, so it seems to me that the relocation discussion here is focusing on a specific section of 5036, that is 5036 C2II. And I look at that. I'm looking at the reg now. I have that reg in front of me. And I see that, and we talked about this with Mr. Lutz, that 50.36 C2II has subservient 4 criteria that it lays out. It says quote, "A technical specification limiting condition for operation of a nuclear reactor must be established for each item meeting one or more of the following criteria." And there are those 4 criteria, right? Well, what about number 3, the bottom? I mean, I'm just a lawyer here. And here's something, this is about surveillance frequency. And all of a sudden I find that the tech specs have to be established for surveillance. And that says 50.36 C3 surveillance requirements. Why doesn't that require and mandate that surveillance provisions be tech specs?
They do, and in fact, we meet that.
Okay.
I'd like to, in fact, refer to that very page referenced by Mr. Lutz, which is attachment 1, volume 7, page 88 of our application. And there you're going to see for the reactor coolant system, we still will have a license, a limited condition for operation in LCO on operability of our reactor coolant system. We will still have an action statement.
Well, wait a second, let me stop you there. I mean, I'm looking at the tech spec regs. The tech spec reg has a subsection C. And C says technical specifications will include items in the following categories. Category 1, safety limits. Category 2, limiting conditions for operations. 3, surveillance requirements. We're not talking about limiting conditions for operation. We're talking about category 3 now. Why isn't it caught by category 3?
It is, and on this very page that he referenced, we still will have the surveillance requirement right there in the tech spec.
But you mentioned limiting conditions for operation. That's what triggered me. Well, that's the wrong subparagraph. That's paragraph 2. I'm talking about paragraph 3.
Yeah, I understand, and I also wanted to respond to something Mr. Lutz had raised.
But don't worry about him. Respond to what I raised.
And the surveillance requirements are not being removed. The only thing that's being removed are the surveillance frequency.
So the surveillance requirements is, hey, you should do some surveillance when you feel like it. And that's all?
No.
The frequency and how you do it and all those things. Oh, that's not covered by subparagraph 3?
It's not how we feel about it. It's we must comply with NEI 0410. We cannot change our surveillance frequency.
Well, I'm reading the reg. I'm not reading the reg. You must comply with the regs first.
Yes. And
Where you don't have to comply with NEI, whatever it is, at this point, do you?
And Judge,
is it in the permit now?
If you look at 50.36 under paragraph 3 that you mentioned on surveillance frequency,
Right.
there's nothing in there on surveillance frequencies. Frequencies are not mentioned at all.
Right, I agree with that. So your point is, well, surveillance, subparagraph 3 of 50.36 C3 is just surveillance requirements. It doesn't talk about frequency.
That's correct.
And frequency isn't covered by that requirement.
That's correct.
Now, okay, I mean, I think that's a logical possibility. Is there any... Can you give me some citational help for that in terms of legal?
Well, only to the fact that other plants have already done this. Comanche Peak, for example, we cite that in our...
I mean, is it been decided? I mean, is there some legal authoritative proposition that when it says surveillance requirements in 3, that doesn't include frequency? I mean, I know the staff has said that. Let's posit that the staff says that.
Yeah.
How about us?
I don't know that there isn't any case law on that. But again, the staff, the NRC as an agency has done this for other plants. And of course, the staff has endorsed the tech spec improvement program that the industry's established. All we're doing is using the standard industry process endorsed by the NRC staff.
So the concern that Mr. Lutz has, since he didn't raise any issues regarding the NEI 410 process, the concern is simply that those surveillance frequency determinations are outside the purview of the public because they're no longer license amendments.
The numerical value of the frequency is outside their purview. The control process is not. Obviously, because we're committed and required by the tech specs to comply with NEI 0410, that document is publicly available.
I understand, so that if there are changes to that document, that would entail a license amendment change.
That's, if we want to move to let's say, a later version of that, or to some other program entirely, you're correct, we would need a license amendment.
All right, and then a petitioner would have the ability at that time to question the adequacy of that document.
That's correct.
Okay. And what is it that, and we mentioned earlier that there are literally hundreds, perhaps more, surveillance frequency determinations that are made that have never been in the purview of the public. And I really don't have a feel for what the percentage is now that we've added to that. But why would you say that it's acceptable to do that in this particular?
Just given the very detailed provisions in NEI 0410, and I'd like to refer the board here to a checklist that's actually attached toward the rear of that guidance document. I have copies here for the board and for the staff if you'd like to see these. But it goes through a number of different criteria, just as part of the qualitative evaluation. Forget the PRA aspects. To change a surveillance frequency, we'll need to look at the surveillance test history of the components in question. We'll need to look at the reliability history of the components in question. We'll need to look at whether there's been a history of unavailability of the components in question. And again, that's just the qualitative evaluation. We also have to look at various other aspects, such as the vendor's frequency specified period. And there are, I think, a list here of 11 some categories. And that's just, again, the qualitative aspects. In addition, we have to look at the impact on the core damage frequency.
All right, but but at a higher level, this particular process is not in violation of any regulation. There hasn't been any rulemaking associated with this process, so it's a commission policy change within their purview. Is that really what we're talking about here?
I believe that's a fair statement, yes.
When you on the NEI, you're talking about this NEI 0410 document and the process, and I am looking at the July 6, 2009 Federal Register, where that document is discussed, and it seems at some length, and blessed by the staff at some length. But under that NEI 04-10 Rev 1 process, you say we would have to look at this and we would have to look at that, and we would, when you say we, you mean Edison.
That's correct. And of course, we're subject to
Now, that's my question is, to what extent is the staff involved in that, looking at all those criteria, or is it kind of like what Edison did with the change in the steam generator? They kind of did it in their own corner and that was it, and nobody looked at it.
Well, Judge Carlin, I would not agree with your characterization of what was done.
Well, it seemed like they did a 50-59 and on their own, unilaterally.
Yeah,
And this is a unilateral thing that you can do under NEI 04-10?
I just want to state for the record, because it's important because of many other issues.
Sure,
Your
okay.
characterization of what was done for the steam generators is not correct.
Okay.
Importantly, that is just not an issue in this.
That's not an issue. But is it a unilateral thing that the SCI, Edison looks at and says, well, and we did all those steps that NEI 04-10 said, and it looks good to us, good to go.
The staff will have to speak to its frequency that intends to perform audits, but we are required to have documentation of all of this.
And if you've done that documentation, you don't have to ask Mother May I from the staff or anything, just do it.
That's correct.
Okay, so
Let me ask you a quick question, and then I have a little longer one. You just said the staff performs audits. Now, how is that audit requirement come about on the surveillance frequency program?
NEI 0410 says that we must have documentation to be available for NRC audit. The NRC audit program is subject to separate NRC programs, inspection procedures, and they can speak to their own program.
Can I just jump in right there? I mean, okay, but let me ask, let me see if I can compare this to the 5059. 5059, as I understand it, allows the licensees to make certain changes without a license amendment if they meet the criteria prescribed therein. And as I understand it, the licensee can make those changes unilaterally, do the analysis, make the changes, and they have to document what they've done. And then it says in 5059, let's see if I can figure this out, C2, that the licensee has to submit a report about the 5059 changes that it's made at intervals not to exceed 24 months. Does that ring a bell?
Yes.
So there is at least an affirmative reporting requirement at least every 2 years on any 5059 changes that a licensee has made in that interval, right?
That's correct.
Is there an affirmative reporting requirement on the changes that the licensee may have made under NEI 0410?
No.
Affirmative reporting
I
requirement.
do not believe so.
So unless the NRC wakes up and does an audit, they're never going to know about it.
So there would be a
No, I want to
relaxation.
answer that. I want to answer that. Is that correct?
They may or may not. I will mention that the courts...
There's no automatic reporting requirement that you have to do
That's
at any
correct.
interval.
But the NRC does have a resident inspector program. I assume that the resident inspectors will be aware of these types of changes.
So that is it results in a relaxation of oversight then? Yes or no?
The entire relocation is intended to give the licensee more flexibility. That's the whole purpose.
So it's a relaxation of oversight.
In the fact that we are no longer
No.
required, we are no longer required to get NRC approval. That's a change, or you
Well, not only that, but even if under 5059, you don't even have the reporting requirements.
And again, I think 5059 really, it was not applicable before, and it's not applicable now, except for the fact that we make a change to the tech specs, we need to get a license amendment.
So let me go on to a different topic. I have the 1977 FSAR, and I happen to just pull out the section that deals with the reactor cold pump pressure boundary. And then it references, it says in-service inspection. Inspection and tests, I believe, are what we're talking about. Is that correct?
In-service inspection, in-service testing is sometimes very different from surveillance frequencies or surveillance requirements.
Okay.
For example, many times, depending upon the nature of the component, it only has to be subject to ISI in-service inspection once every 10 years.
Right, that happens to be the case here, but are you moving those requirements into these documents?
No, we're not.
So those are going to remain in the tech specs?
No, they're not in the tech specs right now. They're subject to the ASME code and our in-service inspection program and our in-service testing program. And this tech spec amendment change does not.
So it will not impact those. That's what I wanted to find out. Thank you.
Okay, I think I have one last question for you, Mr. France, at this point. I think I heard somewhere earlier that our surveillance frequencies is the proposal that has been, the license amendment request submitted by Edison entailed moving all of the surveillance frequencies into licensee controlled documents, or only some of them?
I don't recall, Judge Carlin. I believe there might be a couple that remain, but in general, I think it's fair to say that they're being removed.
And so
Relocated.
how many surveillance frequency provisions are there that are being moved? I mean, Mr. Lutz has shown us in his addendum, the certain number, and how many are we talking about?
I don't know. It's I think fair to
Hundreds?
say, most likely.
Over 1,000?
I don't know.
Okay. Any more questions for Mr. France? No. Okay. Thank you, Mr. France.